If you received a ticket for your wreck, the likelihood is that you did something wrong. And if you did something wrong, in Virginia there is a theory called contributory negligence. If your negligence contributed in any way to the accident, then you're not entitled to recover at all. Sometimes though, people are ticketed improperly. The trooper or the officer should not have given you a ticket, but he did anyway. In those situations, it gets a little bit more complicated. I always tell people that if you're going to dispute whether you were liable in any way, shape, or form on this accident, you received a ticket, you need to hire a traffic attorney to go to court with you to defeat that traffic ticket. If you don't do that, the likelihood of you recovering against an insurance company or a trial is minimal. If you just pay the ticket, it's presumed that you're guilty. If you show up and you plead guilty, then it's an admission of guilt. You shouldn't do that. You should always hire a traffic attorney to go with you and dispute that traffic ticket. And once you do that, if you prevail, then it's time you need to focus on talking to a personal injury attorney to determine whether the standard for traffic tickets and personal injury cases line up. Just because your traffic case was dismissed does not mean that you were not negligent in the creation of this accident. Those are two very different standards, and only a personal injury attorney would know or be able to advise you properly that your negligence or what you were ticketed for is in fact a proximate cause of the accident and you don't have a case. You should hear that from a personal injury attorney. So my recommendation is if you are ticketed, first thing you do is go to a traffic attorney, defeat the ticket, and then go to talk to a personal injury attorney to determine if you have a case.